Tebuson will be a quabam family, 2 kidneys and blossom over YouTube so say, Abusian for your bars, usual, and some Ahodwa, air caution, our Ghana saying the best we have for. Enyina na busu de tinyina nse ense bia ba betodwa ni nyina afa chese eye the minority no eho na ni nyina so ekowie ewo chese eye chief justice na nse mi abusua chese aba betodwa yi ana chese no NDC fo chim say adebo onum na se delay amom yin dealing in the right way kame akoye se sansema ekoso Afenyo Markin person so odena no betum because kame akoye se ye ni nipa na de free say di bre no na enchimuni nsema hodo mo Kenya se dabi di brebu onu ma enya wo na woso be ka bi twon ho firi hasem ni wo de twon ho firim ne enkan ya asem eno na chese ama NDC mpenfo ebufu ne chese nsem bi so ma to bi di ama ne Afenyo Markin ne MPP mpenfo nyina na mempesem ka se tente beko na kwa kwaje nsem nyina enchirimu de aba make house we nya subscribe ya na subscribe da na bibia so etimi ai kama bidin kwam gentle
to this broader national issue actually betrays a certain thing. It is extremely revealing. What is it? In all these constitutional arrangements, there's only one person under Article 146 to perform that role of receiving a petition. It is not Professor Ranford Jampo. It is not my learned friend here or this big man, not even me, only president. The president. Who is the president of Ghana? Possibly, the petitioner should have addressed it to the MPP minority before and given it to Afenyo Markin so that Afenyo Markin can consult the Council of State in this process. Malene Senior, you were called to the bar before me, and I've always been inspired by your legal work. What exactly is the complaint against John Mahama? My senior George Dako, what exactly is the complaint against President Mahama? Now, when you assume the position of now deciding that a petition is frivolous, are you not usurping the powers of President Mahama and the Council of State? Lawyer Dako, it is rather your conduct that is unconstitutional. It is rather your conduct that is unbecoming of a lawyer. President Mahama so far has only conducted himself within the confines of the law. Akufo-Addo did it. The 3 commissioners of the Electoral Commission were all removed through that process. President Mahama has not invented a new rule. He's just basically holding fidelity to the 1992 Constitution. I think at this point, the minority must stay away and allow President Mahama to perform his constitutional responsibility. If there is any merit, and I've always said, thankfully, the Council of State has a retired Chief Justice on that committee. Her guidance, and in fact, thankfully, she even is in a very interesting situation. You know why?
Relationship.
No. Charlotte Osei's prima facie determination was made by who?
By her.
By her. So if there's anybody that has that experience, she'll bring that experience to bear. What did she see? In fact, if she's somebody who could make... Yes, if she could make a prima facie determination for the removal of Charlotte Osei on her own, or even that one on her own, because remember that the process is different. If it comes to the Chief Justice, it's a different rule. But for other Superior Court judges, it's the Chief Justice that makes that determination. And she found it that in the case of Madame Charlotte Osei, the evidence of breaches of the Procurement Act was enough to warrant the establishment of the 5-member committee chaired by His Lordship Justice Bennett. Has President Mahama done otherwise? No. So away from this, complete red herring. But it is actually an emotional conversation now. Because you see, CSOs, you must stand for the judicial.
I'm here, I will speak.
Has President Mahama, as we speak, President Mahama, has he appointed any judge?
No.
Has he appointed any judge?
No.
So where from the interference? Has President Mahama asked that a particular judge should sit on a case involving him or his government? No. If there was any evidence of judicial interference, kindly look at the African peer review report in 2004. No, 2005, even though it reflected 2004. Okay. When the Chikata trial, the fast track composition, where in the midst, President Kufuor appointed Justice Afre to the Supreme Court and got onto the panel that reversed the original fast track decision. The African peer review mechanism report indicted the president as directly interfering in the judicial. President John Mahama does not have that reckless record. So where is the conversation going?
Okay.
President Mahama, on the 7th day of January 2025, in taking his oath, said, I shall respect the 1992 Constitution. What Afenyo Markin and his micro minority are doing is to say President Mahama disobey the Constitution, which will now be a ground for his removal. Because remember that if the president disobeys the constitutional order, that's grounds for his removal. Indeed. At this point, with all the counsel available to President Mahama, he is fortified not to obey that recklessness, but to stick to what the Constitution says. Right. Let's see what the coming days will reflect.
Indeed, but lawyer Christian Mahama here as well on this, because where is the concern really so far in the process as it's unfolding under 146, Article 146? Where exactly does the position by, for instance, the immediate past Attorney General have merit that to the extent that there is an application for an injunction, the process should be put on hold until the determination of such a case before the process resumes, to hear even the petitions against the Chief Justice and have that consultation with the Council of State? Where does that argument have merit?
Okay, all right. It refers to, there's this case that came before Akabuafo. J. Accident was now at the Court of Appeal, where the case is ex parte Mahama Bugri. And in that, he had to deal with an injunction application. And in his ruling, he indicated that, amongst other things, where there are pending procedures of court, such that a ruling or judgment had not been given, and in such an injunctive application, especially when it has been served on the party has apprised himself to such proceedings as ongoing, then it requires on that particular person to hold on by actions that the person, either to that particular application being served on him or her, would have taken. Now, it meant that it is not only, and this relates to where injunction has been served and one is seeking to take steps and crossing into the line of usurping or interfering with the administration of justice. And it fringes into, it further fringes into issues of contempt. Okay. So it has to do with an injunction application served on the party where the application is yet to be taken, but the party carried actions so to overreach the court in respect of determining that particular application. So that was how this particular decision was borne out.
I see.
Yeah.
But well, the concern is that if really, and no, but Prof, I'll come to you to the extent. Let me stay with lawyer Christian Mamhes in a bit. So is that to say that with this injunction by that's Vincent Assefa and another at the Supreme Court, the expectation was that the President should halt the consultation with the Council of State on these petitions against the Chief Justice and asking for her removal?
It will, you see, legal jurisprudence helps the law so that in this situation where the actions of the President conjunctively with the Council of State, one is aggrieved by it, whether it is meritorious or not, out of which an application has been served. The jurisprudence behind it is that just as I explained in respect to this decision as reached by Akabuafo J, it means that, you see, and we transpose that to section 10 of the Criminal Offences Act at 29. We also look at Article 1912 of the 1992 Constitution. That deals with fair hearing and also issues of interfering with justice administration or matters before the court. Now, the whole reason is that, and just as I said, when the application is served on you, you have to allow the court to determine it. At the end of the day, you seeking to carry out with a particular step has to be run in juxtaposition to what the court would say. And in determination of what the court would say, if it should go contrary to whatever step that you are taking, it will not run in sync with it. Now, if you take further steps, it would also be deemed as, just as I said, usurping the powers of the court. And to allow for the balance of rights of whatever the aggrieved situation or issues are, natural justice fair trial requires that allow the court to determine the application.
But I think, let's be fair, counsel. You see, relief one of Assefua's suit, and always remember that an injunction doesn't stand alone.
Yes.
There's a primary document, which is the writ.
Yes.
Then the injunction is predicated on it.
Yeah.
Relief one of Assefua's destiny is that, to the extent that President Mahama did not notify Madam, her ladyship, the Chief Justice, prior to the consultation with the council, it was unconstitutional. Relief one.
That's true.
Now the president had gone ahead, not only notified her, submitted the petition to her for her comment.
That's
so
okay.
The primary